5 periods.
Put number 5 is not there.
No, and confirmation of provisional bill.
Yeah.
The matter relates to confirmation of provisional bill. Day after tomorrow, on 30th, it will expire. I have filed the IO.
Tomorrow the court is available.
That's I'm mentioning my listed tomorrow.
Post tomorrow, but just.
My lords, from the list, CL 29, criminal revision. Maybe heard.
What is it?
It is regarding check bounce matter. He has not complied the order last week. CL 20.
Let the case be called out. We'll see what is called out.
From database of final disclosure item 1, 1029 of 2017.
In this case, the lower court report is necessary because the petitioner has come up before the court earlier against the order of acquittal, and the petitioner was directed to
There are
file.
2 orders of acquittal. Why do you need lower court?
Because both the court below has not considered the evidence on record.
Which evidence have they not considered? Which evidence have they not considered?
PW 1 to 6 minutes. All have supported the case as it appear
इसका
from
record नहीं
the.
आया है?
As it appear from
You have
the.
got?
I'm for the number 2.
Which evidence you
If
want?
you also can you see the paragraph number, trial court judgment para 10, 11, 12, 13, 14 and 15.
So what has not been considered?
Because they have supported the case of the prosecution and the trial court has said they are the tutor witness. That's why I am referring the paragraph number 10 onwards.
They have considered the cross-examination of the witness also.
This is the reason.
They have considered the cross-examination and you were not in possession of the property.
Kindly see the paragraph number 10.
There is no scope of reappreciation of evidence. You have to show the ex facie perversity in the
Yes,
case.
but this is the
There is
reason.
no scope for reappreciation of evidence in revision. To
Because they have not considered they have only said that they are the tutor witness.
no, they have considered the cross-examination and then said that they are the.
No. Kindly see paragraph 10.
Yes, all the cross-examination has been considered. How do you say?
May I permit to read? Paragraph 10 onwards. Basiruddin Ansari CW1 is a farmer from the Kakrar. He has stated that the offence taken place on 10/12/2007 about 6 am. He has further added that same time he had gone to see the paddy land, during which he saw that the accused persons, namely Riaz Khan, Abdul Miya, were catching the fish in the pond of Ram Prasad Halwai, while the other accused persons were standing there. He has further stated that when the complainant came at the PO, the accused person threatened him to leave the place. The witnesses have further stated that the accused persons caught fishes, weighing the approximately 1 quintal and took it away to their house in 2 baskets. He has further stated that apart from him, other witnesses, namely Kamruddin Miya, Bake Bihari, Sanjay Gupta, Zakir Miya, Mahmood Ansari and Majid Ansari saw the occurrence. He has further stated that the complainant had reared the fish. These witnesses have pronounced all the accused persons present in court on prodding the defense. The witnesses has given description about the Johati of the place of occurrence. However, these witnesses candidly stated that he has given that the very evidence which he complainant told him to adduce. This single statement of the witness goes to show that he
complainant tutored witness है, complainant ने जो बोला वो आके बोल
नहीं इसके पहले
यही तो है
तो बोल रहे हैं कि हम देखें
यही ना जब क्रॉस एग्जामिनेशन में इसे कंप्लेनेंट ने जो बोला हम आके बोल दिए बात खत्म हो गया बताइए now in revision how do we reappreciate this evidence?
So I am in this case petitioner prays for filing the acquittal appeal by filing the revision application. This is not the against that judgment. The petitioner prays for.
There are two judgments of acquittal.
Yes, ma'am.
Now you say that what is it that this order is to be set aside? Two judgments of acquittal. It's not ordinary thing. We will not reappreciate the evidence. You tell us that what is it? Rather, it has come in the evidence of the complainant that police had come to give him possession.
No, this is the complaint case, no? In which
In the complainant himself has stated in his evidence that police had come to give him possession. It means that he was not in possession.
he has filed the title suit which was
Maybe
title
declare हो गया possession. Possession is
title
a
suit was
different thing
declared in his
altogether. He has himself stated that the police had come to give possession. He has himself stated. Read it.
title appeal was the
So what?
OP number 2 also lost. Thereafter they preferred the second appeal before this.
Title and possession are two different things altogether. दोनों एक बात नहीं. You just see para number 15
Yes.
of the trial court judgment. Read para 15.
In which
Yeah, last में. He has further stated that the police had come over the place to give him possession over pawn, but when the possession could not be produced, he lost the instant case. He has also admitted that the police station was informed in writing about the occurrence. He candidly admitted that prior to the case and even after this case, the litigation over the pawn is going on between the parties. However, on proluding by the defense, he has denied that the pawn in question was in possession of the accused persons. क्या है? पुलिस आई पोजेशन देने के लिए और कहानी हो गया शुरू.
In this case, the trial court has not at all considered the evidence of PW 1260. That's why I am asking for.
You tell us it is fully considered. Everything is mentioned. Each and every witness has been discussed. How do you say not fully considered?
On a true aspect, no, they have not discussed the trial court has not discussed.
What aspect?
Because the PW1 is the eyewitness in this case.
So what? He has been disbelieved by the court because he has deposed that he has come to the court at the instance of the complainant and complainant जो बोला.
Because this is the complaint case and the complainant made the PW 1 to 6
So
PW 1 to 5 as a witness.
He has been cross-examined, and then during cross-examination this has come. The court has disbelieved it. And what is the scope of reappreciation of evidence in divisional jurisdiction? The court has disbelieved this witness. What do you have to say?
Yes, madam. In consideration of the paragraph 15 of the trial court judgment, details has been discussed there with respect to the witness as well as the place of occurrence is concerned. And similarly, my lords, in the appellate court judgment also in the paragraph number 16 categorically it has been discussed the evidence on behalf of the complainant is concerned, and thereafter the material of the evidence is there.
लिखिए क्रिमिनल रिविजन नंबर 1029 ऑफ 2017. आप स्टेट हैं? आपको क्या बोलना?
There is no purpose.
सबको अपना appearance दे दीजिए please. This revision has been filed against the judgment dated 17/7/2012, passed by learned judicial magistrate first class Dhanbad in CP case number 1998 of 2017 with the bracket TR number 861 of 2012. Whereby the learned judicial magistrate acquitted the opposite party number 228 in connection with the alleged offence under section 147, 341, 427, 447, 379/34 of Indian Penal Code. The petitioner has also challenged the judgment dated 16/2/2017 passed by learned district and sessions judge Romanpur Dhanbad, passed in criminal appeal number 88 of 2013, by which the appeal preferred by the petitioner under section 372 of CRPC has been dismissed. The Learned counsel for the petitioner while assailing the impugned judgments of both the courts whereby the accused, given that opposite party, private opposite party number 228 have been acquitted, has submitted that the learned courts have not considered the evidences properly and has passed the order of acquittal. The learned counsel has also submitted that the judgment in connection with the pawn involved in the present case in title suit has attained finality. The learned counsel has in particular referred to the evidence of CW1 and has submitted that he was eyewitness to the occurrence, but the learned trial court has not considered his evidence properly. The learned counsel has submitted that the impugned judgments are perverse and therefore they call for interference. The learned counsel appearing on behalf of opposite party number 228 has opposed the prayer and has submitted that both the courts have considered the evidences on record and it has come and has in particular referred to paragraph 15 of the trial court judgment to submit that
15 of appellate court judgment.
And then trial court.
trial court judgment, 15 of trial court judgment to submit that the complainant during his cross-examination has admitted that the police had come over the property to give him possession, but when he could not get the possession of the land of the pond, he has filed the complaint case. The learned counsel has submitted that the CW1 has been cross-examined and it has been recorded by the learned court while disbelieving his evidence that this witness had stated that he had given the very evidence which the complainant told him to adduce. The learned counsel submits that there was a serious dispute in connection with the possession of the property. Merely because the title has been declared, the same does not mean that there cannot be any dispute regarding possession. The learned counsel appearing on behalf of the state has also opposed the prayer and has submitted that there are concurrent findings recorded by both the courts and there is no scope for reappreciation of evidence and coming to a different finding in divisional jurisdiction. This is so particularly in view of the fact that both the courts have acquitted the private opposite parties in the present case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the incident had occurred in connection with one pond and it was alleged that all the accused persons started catching fish reared by the complainant. And as soon as the complainant came to learn, he rushed to the place of occurrence, raised objection, on which the accused person abused him and threatened to kill him. It was alleged that the accused persons had caught about 100 kg of fish and caused damage to the amount of Rs 6,000 to the complainant. It was also stated that the title suit number 50 of 96 was already decided in favor of the complainant and the judgment had become final and it was asserted that the accused persons have no right, title, interest or possession over the tank of the complainant and want to forcefully dispossess the complainant and his co-sharers. the learned court, after closure of inquiry, found prima facie case for offence under section 147, 341, 427, 447, 379 and 34 of Penal Code. At the stage of trial, the complainant had examined altogether 6 witnesses, including himself as CW6. He had also adduced evidence in connection with the judgments, and following documents were exhibited. No witness were examined from the side of the defense. However, the defense also produced a number of documents as under Exhibit A2, Exhibit B रहेगा defense का, उनका Exhibit 1 to Exhibit 4 रहेगा. You will find it at running page 32. During the course of argument, it was a specific case of the defense before the learned trial court that this court finds that the learned trial court has discussed evidence of each and every witness produced from the side of the prosecution, including their cross-examination, the learned trial court, since the counsel for the petition has in particular referred to evidence of the complaint witness number 1 and claims that he was an eyewitness, this court finds that the learned trial court has considered the cross-examination of the said witness and have found that the said witness had stated that he had given the very evidence which the complainant had told him to adduce. On this ground, the trial court has disbelieved the evidence of CW1. This court finds that the trial court has committed no error in disbelieving the evidence of CW1. The learned trial court has also considered the evidence of other witnesses, and while considering the evidence of CW6, the learned trial court has recorded as under para 15. Upon perusal of the discussion made by the learned trial court while considering the evidence of CW6, the learned trial court has specifically recorded that the complainant had stated that the police had come over the place to give him possession over pawn, but when possession could not be procured, he lost the instant case. The evidence of CW6 itself revealed that there was a serious dispute in connection with the possession of the property. The learned trial court ultimately acquitted the accused persons by citing as many as 6 reasons as mentioned in paragraph 16, which are quoted as under. The learned appellate court also considered evidences on record and has specifically recorded that there was a dispute in connection with the pawn and the appellant did not have the possession of the pawn. Considering the totality of facts and circumstances, this court finds that both the courts have discussed the materials on record and have considered the aspect of the matter regarding dispute of possession over the land. The complainant himself had admitted that the police had come to hand over the possession to the complainant, but he could not get the possession of the pawn. In such circumstances, this court is of the view that both the courts have passed judgment of acquittal, and there is no scope for reappreciation of materials on record and coming to a different finding. Both the judgments are well-reasoned judgment, and this court finds no illegality, perversity, or material irregularity in the judgment passed by the concerned courts. Accordingly, this revision is hereby dismissed.
Item 2, Intelligence 851 of 2020.
I propose you bill number 2.
Yes.
Mediation, the case is on
Mediation has failed.
Mediation में जाती भी नहीं है कुछ को कर
Mediation has failed. आप बहस करिए अपना केस. You argue your case.
senior will accept that total let's say it is last year. We have not no information that medicine has not get it was referred.
आपको कोई चीज़ का information नहीं रहता है. Yes.
They had filed supplementary affidavit also depositing 2,50,000 and 20,000 also.
It doesn't make any difference. You argue your case. On the last date, your senior was appearing on 12/8/2024, and it has been recorded by this court that the matter could not be settled through mediation. अभी आपको knowledge नहीं था कि mediation fail कर दिया. कुछ भी बोलते हैं कोर्ट में.
As per instruction, I
ये order upload नहीं हुआ. Yes, and in his presence, this order was passed. You can get away saying anything in the court. You argue your case. I will not give adjournment. You argue your case. Uploaded order भी पढ़ के नहीं आते हैं कोर्ट में. And then you will say that you are not aware. You argue your case. Argue. बताइए.
possible कर दिया था. I have no instruction.
दो इंस्ट्रक्शन डिसमिस कर देंगे आपका.
From my senior.
ठीक है 12 बजे बुलाइए. नहीं आइएगा तो यहीं से एकदम कुछ भी नहीं, 1 मिनट भी इधर उधर नहीं. झूठा सबमिशन मत किया करिए हमारे सामने. मेरा दिमाग खराब हो जाता है.
As per instruction, I have.
व्हाट इंस्ट्रक्शन? आप इतना देर से 10:30 बजे से यहाँ बैठे हैं, अपलोडेड ऑर्डर नहीं देख सकते हैं? We are fools. We are fools sitting over here ensuring that every order is uploaded. Or you are technologically crippled. आपको ऑर्डर देखना नहीं आता है? आता है कि नहीं आता है?
आता है.
हाँ तो फिर कोर्ट में बैठ के लास्ट ऑर्डर भी नहीं देखते.
I will call.
Are you a robot? Yes?
No, it's-
Item 3, Intelligence 1168 of 2017.
In this case, in the earlier occasion, the NBW issued by the concerned trial court has been stayed, my lord, and it has been fixed for final argument.
It has not been stayed, it has been set aside.
Set aside.
Yes, at your instance that you will argue the case today. And now you think of a situation, NBW must have been issued after cancellation of bail bond.
No, my lord, here the case was dismissed for default partly.
That's right.
And on the basis of that, my lord, it was.
The bail bond must have been cancelled.
Yes, and
Now
then-
you are let loose without any bail bond. Right?
Yes, ma'am.
Argue your case and don't wait for time.
Monday indulgence.
No, I will not give you
Because-
no indulgence at all. It was certainly, I realized it later, it was certainly a part of your duty to inform this court that the bail bond has already been cancelled. I didn't realize it by setting aside the.
But sorry, my lord, I was the first time I'm.
I know, I will not grant you
I'm-
time. I will not grant you
As your
time.
lordship pleases, my lord, I'm not asking for time. Whatever, my lord, I have read, I will assist your lordship.
Right.
The case is like this, my lord. The informant happens to be an executive magistrate,
Yes.
and it has been alleged in the first information report that these three of the accused persons, out of which the present petitioner has also entered into the chamber of the executive magistrate and asking for him that why the death certificate of the present petitioner has been cancelled. And on the basis of which there was a hot talk between the petitioner and the informant, my lord. And thereafter the police was called upon and he was taken away from there, and on the basis of which, my lord, the case under section 353 and 504 has been lodged against the present petitioner, my lord. From the entire allegation, my lord, the main thing is that, my lord, no criminal force has been used in the entire allegation. My lord, there are, for bringing home the offence under 353, there are 3 ingredients, my lord.
Later I will say. So you have been charged for offence under section
354, 353,
353,
448,
448,
504,
504
and 34 of IPC.
and 30.
Subsequently acquitted under 448, conviction under 353, 504, read with 34.
Conviction 353,
504, read with 34.
acquitted 448
Under 448.
by the trial court.
Trial court and found by the appellate court.
So 353 you say
There
that
are, first, the concerned person, informant, should be a public servant. Second, that he has used a criminal force. And third, that he was stopped from discharging his official duty. Now, prior to this, my lord, there are 3 definitions which are very important, my lord. Force, criminal force, and assault. Because word assault and criminal force both has been used in the section 353, my lord. (349) speaks about force, my lord.
349.
Yes, my lord.
Yes.
May I read 349 for please? A person is used to force to another if he causes motion, change of motion, cessation of motion to that other, or if he causes to any substance such as motion or change or motion or cessation of motion, as brings that substance into contact with any other part of the other's body, or with anything which that other is wearing or carrying, or with anything so situated that such contact affects the other's sense of feeling. Now there is a proviso clause, my lord, subsequent to that. Provided the person causing the motion or change of motion or cessation of motion causes that the motion, change of motion, or cessation of motion is one of the 3 ways hereinafter described. Firstly, by his bodily power. Secondly, by disposing any substance in such a manner that the motion or change or cessation of motion takes place without any further act on his part or on the part of any other person. And third is, my lord, by inducing any animal to move, to change its motion or to cease to move. So this is force, my lord. Now 350 is criminal force, my lord. Criminal force is whoever intentionally uses force to 350.
Yes.
Whoever intentionally uses force to any person without the person's consent in order to committing of an offence or intending to use such force to cause or knowing to likely be that by use of such force he will cause injury, fear or annoyance to the person to whom the force is used, or is said to use the criminal force to that other. Now, Leadership may kindly come to 351 assault. Whoever makes any gesture or any preparation, intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes that gesture or preparation is about to use criminal force to that person is said to commit an assault. Now, my lord, 353. Whoever assaults, first is assault, my lord, or uses criminal force to any person being a public servant in execution of his duty, as such public servant, or with an intent to prevent or deter that person from discharging his duty, my lord. So the prime ingredient that force has been used, and because of which, my lord, the public servant has not been able to discharge his duty. As such, the public, or in consequence of anything done or attempted to be done by such person in the lawful discharge of his duty as public servant, shall be punished with an imprisonment, either description for a term which may extend to 2 years, or fine, or with both. Now, leadership may kindly see the allegation here in this case.
Which ingredient is missing?
First ingredient, there is no criminal force
Just
nor
one-
assault.
Just one. No criminal
Force
force,
or assault.
no assault.
And second, leadership, that it has not been alleged that he was stopped from discharging his official duty. He was sitting in his chamber. The petitioner and two other persons entered the chamber. There was a hot talk. Matter finished up there. He has never been seen. So he has no evidence has came to show that he was stopped from discharging his official duty. He was sitting in his chamber. The chamber was adjacent to a court where he used to dispose of cases and hearing the advocates and other. But he was not sitting in the court, my lord. He was sitting in his chamber. At that time, the three persons entered and they were asking that why you have cancelled my father's death certificate. He stated that there are some anomalies, and on the basis of which the hot talk started, and then the orderly and other came, and then the police was called upon, and they came there and intervened. This is the simple case of the prosecution. So, three of the ingredients are not getting fulfilled, my lord. The main evidence of PW4 may kindly be seen, my lord, who is the informant of this case, which has been discussed in page 34 of the judgment of the appellate court, my lord. Internal page 5 of the appellate court judgment. I'm only going
It
to
come from the trial court judgment. Let us see what is the discussion and
Yes,
findings
yes.
of the judgment.
I'm coming to the trial court judgment. The finding of the trial court starts from internal page 3, my lord. May I read, my lord? Heard both the parties and perused the entire case records. On perusal of it, it appears that PW1, Bhavani Das, is in his chief, is in para 1, has admitted that he was the orderly of the informant's office, where accused person entered into the office of the informant and started abusing the informant for issuance of birth certificate, due to which there was some hot discussion between the accused and the informant. In para 2, he has stated that these accused persons also abused the informant and created scene in his office, for which the police were called upon from the Charles police station and later on
This is
arrested.
the birth certificate or death certificate?
Death certificate.
या तो birth certificate डेथ होना चाहिए ना?
Death होना चाहिए. ये typographical mistake.
Yes, continue please. Please read it.
Yes, madam. In para 3, he admits about the identification of the three accused persons. During cross-examination in para 5, he has admitted that it was a common feature of the public who generally entered into hot discussion with the informant and his bench clerk. In para 6, has stated that these three accused persons always come to the informant's office regarding the death certificate. It has further admitted that chamber and office of the informant is same. His subsequent para has stated that he never asked the reason from the informant about coming of the accused person daily to his office. In the same para has further admitted that due to such hot discussions and scene created by the accused person, the informant had stopped his work. He in para 9 has further stated that the bench clerk Sri Safi Ahmad and others remaining staff along with public reached at the place of occurrence after the incident got over. When the incident got over, so they were not an eyewitness. In para 10 has admitted that he was ordered by the informant to call the police, which was obeyed by him. In para 11 has further admitted there was a difference in the date of death which was issued by Samsan Ghat and what is written in the affidavit. In para 12 further admitted that the police has not taken his statement except the name and address was asked by the police in his office on the next date of occurrence. Now PW2, one more orderly man. Munna Singh. In his chief has admitted that he has not seen the occurrence, only heard about it. In para 1 itself has admitted that after hearing the noise, he reached at the chamber of the informant, where the informant had asked him to call DSP. So he immediately obeyed his order. He further admitted that at the place of occurrence there was a hot discussion between the parties. He further stated as because of the informant told the police to arrest these accused persons, the police has arrested them. He in para 3 has further stated that after he went to his branch, his subsequent para has further stated that he cannot tell that whom the police has taken to custody. In subsequent para, he has admitted the identification of the accused. He in his cross-examination para 7 has admitted that there was a lot of people in the office of the informant. In the subsequent para, further admitted that he reached at the office occurrence after the incident got over. In para 9, he further admitted that accused Ramlal Singh was coming to the office of the informant for preparing death certificate of his wife, but he cannot say about the conversation took place between the accused and informant. So this witness is totally an hearsay witness. Now PW3, one more orderly. Again the same thing, Malone. Vakil Singh admitted that he has not seen the occurrence but heard about it. He in para 3 has admitted that there was a fight in the office of informant. Again, Malone, exaggeration. There is no question of any fight, Malone. He in para 6 of the cross has admitted that no incident regarding the case occurred in front of him, so he has no knowledge about the fact of the present case. It is the staff of the said office who told him about the incident, but he could not tell the name of the said staff. Now, Malad, the informant comes, that is PW4. He is the executive officer. Manoj Jaswal, the informant in his chief in para 2 has admitted that on 5/1/2003 at about 3:30 he was busy disposing of his file in his office. Then all the three accused persons, after abusing him, entered into the office and threatened him. He further stated that the accused D.N. Chobe asked him that why his family's death certificate has been rejected. Then the informant replied that the date mentioned in the Samsan Ghat certificate is different from what is
cancellation of death certificate. The application for death certificate was rejected.
rejected.
Yes. Not a cancellation of death certificate.
No. They have not provided it.
That's all. Proceed.
Yes. If it were given by the accused Rampal. And secondly, the death of Rampal's wife is due to paralysis, but no certificate from the doctor as per section 10 and 3 of the death and birth regulation was filed. It is stated by the informant that on such statements, Sri D.N. Chobe got furious, the petitioner before Lordship, and started abusing him and sat on the chair in the informant's office forcefully. Then the informant asked his peon to call the police from DSP office. He also informed the local police through his mobile. He further stated that local police came at the place of occurrence and arrested the three accused persons. He further admitted that the written report, which bears his signature, is identified by him, and the same is exhibited as Exhibit 1. Form 4, which bears his endorsement in red color, green color, is identified by him, and same is exhibited as Exhibit 2. With objection, The certificate from Samsan Gaj was issued on 7/1/2003 was also identified by him and the same in Exhibit 3 with objection, and the affidavit made by Lal Singh, the accused, on 27/1 also identified him, which is exhibited as Exhibit 4 with objection. He further stated the medical book for the accused wife of Bokaro Steel Limited bearing number such and such, and the ration card in the is also filed the accused Rampal along with Form 4. In para 5, he has stated that apart from the accused Chobe, other accused persons were also abusing him. He, in para 6, has admitted the threatening identification of the accused person. In para 10, he admitted there is a dais made in his office to dispose of the office court work, and the bench clerk and steno sits in the side of the dais. He further stated that admitted there was 8 cases listed in the date or occurrence of the case, and at that time he was yet to dispose of the cases listed for that date. He further admitted the work regarding affidavit starts at 4:30 to 5 p.m. in his office generally. He furthermore admitted that the register is maintained for that affidavit work. In para 14, has further admitted that these 3 accused persons abused him by saying, "Kanunchi bante ho, bante hain." He further admitted that D.N. Chobe has abused him in the above stated language. He further stated that apart from this, his peon Bhagwan Das, bench clerk, and 2 other witnesses of the present case were present at the time of occurrence. That is also false, my lord. They were not present. But he cannot tell the name of those witnesses, though he recognized them by their face. He is not para 16 of the further stated that he called his peon Bhagwan Das at 11:45 from DSP office. During cross-examination, para 21, he has admitted that he has seen the birth and death act, but cannot tell the sections of that act. In para 24, further admitted there was no provision of inquiry of death in the said act. He further 25 has further admitted that if there is no report from Samsan Ghat about the death, then the report or panchayat will help to register the death report by the accused persons. It further stated that if due to some unawareness, panchayat does not tell the birth or death of somebody, then only after inquiry the SDO, the said certificate can be issued by the Jharkhand government. It is further stated that if the SDO has not submitted his report within 13 days, then again the J government, after proper inquiry, can issue death or birth certificate to the person concerned. In his subsequent para, it further stated that after going through Exhibit 2, he has admitted in the cross-examination on the stamp of the block officer charged because as per his statement, the bench clerk has put it on the wrong place. He in para 27 has further stated that the said certificate was not issued within 13 days, so it is still with him. In para 28, he has further admitted that JSS report, it was endorsed by
In his
JSS that...
entire cross-examination, there is no cross-examination on the incident.
Pardon?
There is no cross-examination on the incident. You say a person, executive magistrate, he might be wrong in his action in refusing issuance of a death certificate, right? But incident stands fully admitted in his cross-examination.
Yes.
That's it.
Yes. Now, admitting the incident to be...
Everything, every cross-examination is on
On
his
the
conduct as to whether he has rightly rejected or wrongly rejected.
That is totally
But so
wrong.
far as the incident, the manner of incident, the abuse, and that his work was also pending, and the manner in which these people behaved in the chamber, there is no cross-examination on it.
Because
So
even
his evidence is intact completely.
No, not intact. Well, even taken to be true in its entirety. Well, whether abusing will come under the ambit. So I am going to 3 definitions. I have
Not only abusing, there is more to it.
abusing, assault, criminal force. It should be, there should be a force.
Entering the chamber and then behaving in this manner.
No, 353 says, my lord.
We will see each ingredient. Don't worry about it.
448 goes, my lord. 448.
448, there is no argument on 448.
Because forcibly entering into the chamber is 448, my lord.
Merely because you have been acquitted in 448.
No, I am saying whether the ingredients of 353 are satisfied or not.
That's right.
I am only on this.
That's right.
I can say my 504, yes, it is made out. But with regard to 353, so 353, my lord, there are three ingredients, my lord. So first is the force and criminal force, my lord. Where is the force and criminal force and assault? If cross-examination parts comes later on, my lord. Now first prosecution has to prove the case beyond reasonable doubt in under 353, my lord. Even if I have not cross-examined, whether what has been stated by the witness in the examination in chief and brings the ingredients of the offence under 353 or not. That is the point of consideration before you this honorable court, my lord. There are three judgments, my lord, I am relying. If lordship, after 1 month, half an hour it keeps, my lordship keeps, bring that judgment, my lord. My lord, I have told me, but half an hour after, my lord, that explicitly says that what are the ingredients of 353, my lord.
Which judgment is that?
2015, 4 SCC is there, my lord. There is one explicitly a judgment of Punjab and Haryana High Court and Gujarat High Court.
2015 4
4 SCC, my lord. Page number I am forgetting, my lord. Page number I am giving, my lord. I will bring that judgment if only if,
पेज नंबर बताइए ना, हम आपको जजमेंट देते हैं, क्यों चिंता कर रहे हैं? Give me the page number.
fifteen 7 SCC, my lord.
15 7 SCC
423,
7 SCC 420
423, 16 SCC,
2016 16 SCC
418.
418
One is 1995 SCC online,
1995 SCC online
Punjab and Haryana 157,
157
and one is, my lord, 1996 SCC online, Rajasthan.
1996
SCC online, Rajasthan 153. And one judgment of Kerala High Court in criminal law miscellaneous number 4477 of 2019.
So where do we get
And that I have, my lord. I have got all those judgments, my lord. But
अब
subsequent-
आइए आधा घंटा में लेके आइए सारा
हाँ।
judgments। जो लेके नहीं आइएगा उसको हम रिकॉर्ड भी नहीं करेंगे,
हाँ, सब लेके आएंगे वो।
लेके आइए,
हम
लेके आइए, कम इन हाफ एन आवर।
Yes, my lord, I'm coming in.
आपका ये इतना भर सबमिशन लिखा देते
Sir,
हैं,
इतना?
we will consider the judgments and then
Yes.
discuss that.
But whether the ingredients
The
were
learned
correct.
counsel for the petitioner has submitted that the petitioner was facing criminal case for alleged offence under section 353, 448, 504 and 34. Read with section 34 of IPC. He was convicted by the learned trial court under section 353, 504/34 of IPC, but acquitted for offence under section 448. The learned counsel submits that so far as the office staff of the complainant is concerned, complaint
Informant.
of the informant is concerned, they are not the eyewitness to the occurrence. So the main evidence is of that of the informant,
It is PW.
who was examined as
PW4.
PW4. He has referred to the evidence of PW4 as recorded in the trial court's judgment. And during the course of argument, it appeared that he had supported his case in chief, and during cross-examination, the entire cross-examination related to his official work, whereby he had ultimately refused to issue the death certificate. The learned counsel submits that even if the entire allegation made against the petitioner and the evidence of PW3 is taken to be correct on its face value, no offence under section 353 is made out, inasmuch as the basic ingredients are completely absent. He submits that no criminal force has been used, there is no assault, and there is no allegation that the informant was stopped from performing his official duty. The informant was the executive magistrate before whom an application was made for the purposes of issuance of death certificate, which he had declined to issue. The learned counsel submits that the term force has been defined under section 349 IPC. 350 defines criminal force and 351 defines assault. He submits that in absence of the basic ingredients constituting the offence under section 353 IPC, the impugned judgments are perverse and call for independence. What do you have to say for 504?
504 मतलब with regard to मतलब 504
कुछ नहीं बोले.
मैं अब तक 504
So far as the offence under section 504 is concerned, no argument as such has been advanced by the learned counsel for the petition. अब आप judgments लेंगे.
हाँ
12 बजे आएंगे.
हाँ
उनको आने दीजिए ना जजमेंट, उनको खत्म होने दीजिए उसके बाद. अभी फ्रेश था इसीलिए लिखा था. ठीक है, आप लेके आइए सारे judgments.
Number 4, Criminal Division 903 of 2018.
Who is for the petitioner? Who is for the petitioner in this case? Criminal Revision number 903 of 2018. Nobody appears on behalf of the petitioner. The records of the case reveal that by the order dated 28/11/2023, the petitioner was directed to be released on provisional bail for a period of 4 months. And the matter was directed to be posted on 22/12/2022. Thereafter, the matter was taken up on 22/12/2022 and it was directed to be listed on 18/1/23. On 18/1/2023, nobody appeared on behalf of the petitioner and the matter was directed to be posted after 2 weeks. The records reveal that the notice upon opposite party number 2 has been served. Today, when the case is taken up, nobody is appearing on behalf of the petitioner. And the period of grant of provisional bail has expired long back. The order dated 22/11/2022 revealed that it was submitted by the petitioner on that day that the petitioner was ready to compromise in the case and may pay certain amount after being released from jail. ये किस heading में है? Considering the fact that the period of provisional bail has already expired, the concerned court is directed to take all steps for the arrest of the petitioner and submit a report before this court prior to the next date of hearing. Was this case on 12th of September in the supplementary cause list. Let this order be immediately communicated to the court concerned. So are you sign करके upload करें?
Item 5 of 118.
Earlier, on last occasion, since none had appeared, the case was, the appellant was, when the court below was directed to take coercive stay, and subsequently the petitioner has been taken into the custody, and now he is in custody.
Are you arguing the case? The records are here.
My lord, we passed in next week. We are in the process, 1 lakh rupees already been paid, and that has been received by the OP number 2, and draft of 1 lakh has already been prepared. We will give it. Therefore, my lord, on next, any day in the next week it may be posted.
Bail नहीं देंगे.
My lord,
Bail नहीं देंगे. आपकी मर्जी है.
बिल आज के मांग भी नहीं रहे, हम नेक्स्ट वीक में रखने बोलते हैं, पैसा देके जॉइंट कंप्रोमाइज फाइल करेंगे, ये बोल
You are for the OP number 2.
1 लाख दिया जा चुका है और 1 लाख रुपया देंगे और कंप्रोमाइज फाइल करेंगे, नेक्स्ट वीक में
The
रखेंगे,
learned
अब
counsel
वो
for
कस्टडी
the,
में.
the learned counsel for the parties are present. Pursuant to the order passed by this court, the petitioner has been taken into custody. The counsel for the petitioner submits that the matter arises out of conviction under Section 138 of Negotiable Instruments Act, and he is ready to compromise the matter.
He has already paid the sum of which one.
He is ready to compromise the matter with the opposite party number 2 and substantial amount.
Openly.
हाँ, she
Sabia Khartoum. Sorry, madam. Sorry.
he is ready to compromise the matter with the opposite party number 2 and substantial amount has already been paid. He submits that there is a likelihood of filing of a joint compromise petition in the present case. But so far as the petitioner is concerned, the same will be filed through the paralegal because the petitioner is in custody. Learned counsel for the opposite party number 2 has also submitted that there is a likelihood of settlement out of it. Right? At the joint request of the learned counsel for the petitioner and opposite party number 2, post this case on.
Next
आप
Thursday.
choose कर लीजिए. Choose your date.
Next Thursday.
Next Thursday in the supplementary process.
Yes.
Joint compromise में जरूर से लिखिएगा कि they don't have any objection if the conviction is satisfied.
Yes.
ये defective petitions file होने से it becomes very difficult for us. पैसा लेने से खाली आपका सजा
अब तो
माफ
ये
नहीं होता
डिफेक्टिव नहीं
है.
रह गया, अब तो खत्म हो गया डिफेक्ट. अब आई एम कस्टडी देयर.
नहीं लाइक अभी भी कन्विक्शन सेटिसाइड कर आप निकलेंगे तो तभी ना जब कन्विक्शन सेटिसाइड
Conviction
होगा.
set-aside होगा.
उसके बिना तो नहीं निकल
नहीं
पाइएगा.
निकल पाएंगे.
इसीलिए कन्विक्शन सेटिसाइड करने का
No objection
स्पेसिफिक
होगा.
एवरमेंट
हाँ.
आप लोग सोच समझ के दीजिए.
जी,
बट
जी,
आई एम
सब
नॉट
में-
सेइंग सजेस्टिंग एनीथिंग.
Yes, yes.
बट योर पिटीशन शुड बी प्रॉपर्ली
Yes,
ड्राफ्टेड.
that will.
अभी कल ही आया है एक ऑनरेबल सुप्रीम कोर्ट का जजमेंट कि 138 में कंपाउंडिंग के लिए भी तो एक प्रॉपर पिटीशन होना चाहिए.
बिल्कुल जॉइंट कंप्रोमाइज जॉइंट आईए होना चाहिए.
हाँ, ऐसे
और
होना
जॉइंट दोनों का साइन होना चाहिए, दोनों का एफिडेविट होना चाहिए. वो
इसीलिए आपका लिखा भी है कि पैरवी काट के ही
जी
थ्रू
जी
होगा.
वो कस्टडी में.
Item 6, Criminal Gen 764 of 2020.
Yes, petitioner.
So 279 6 months and 304A 2 years. The petitioner is already in custody as he surrendered on 19/2/24. The only submission for lordship is that though the 6 witnesses were examined and PW5 is the informant who says that the petitioner was driving truck and his daughter done to death by the accident. By which the petitioner was by the said truck in which the petitioner was driving into the accident negligently. This is the case in this.
Yes.
Now only submission for lordship with us is he has already remained in custody more than 6 months. And so for the other parts of the case matter we made it is concerned.
बेल वेल नहीं अब आप फाइनली.
हाँ वही कर रहे थे बस उसी पर कर रहे थे.
6 months कैसे हो गया आपका?
19/2/24 को सरेंडर किए. अभी बाद में सरेंडर किए, डीएफडी हो गया था, सरेंडर नहीं किए थे, इसलिए बाद में सरेंडर किए.
आपको तो एपेलेट कोर्ट थोड़ा रिलीफ दिया है ना?
नहीं डिलीट नहीं. नहीं दिया, सेंटेंस एडिकेटिव माना है.
6 महीना कंप्लीट हो गया आपका?
हाँ 6 महीने से यस. आइए के साथ लगाए हैं सरेंडर सर्टिफिकेट.
क्या बोलना है आपको? आप किसकी तरफ से हैं? स्टेट? ये तो मेरिट पे बहस नहीं कर, कस्टडी पे बहस कर.
बस
ऑन द पॉइंट ऑफ सेंटेंस ओनली.
और कुछ बोलने का है ही नहीं.
तो अपोज करेंगे.
तो विक्टिम कॉम्पेंसेशन देकर कब का केस है ये?
ये केस है अभी 2008 का.
8 एज बताइए। पिटिशनर का एज बताइए।
किसका जो पिटिशनर का? तो पिटिशनर का फिलहाल एज है 39 ईयर्स लिखे से 2020 में, अभी 2043
प्रेजेंट एजेस
43 ईयर्स।
लाइसेंस वगैरह सब था।
वो सब मेरे को डिस्प्यूट नहीं है कि लाइसेंस तो नाम से ही दिया था कि चला।
फर्स्ट ऑफेंस
हाँ, फर्स्ट
सजा कितना दिया?
2 साल है 304A में और 6 महीना है 279 में।
$304A में 2 years
जी,
and 6 months in
in 279।
कोई मिनिमम सेंटेंस है किसी में?
हाँ, मिनिमम को बता दें। टू 79 में है punished with either discretion for a term which may extend to 6 months or with fine which may extend to 1,000 rupees or with both। ये 279 में है और 304A में है punished with imprisonment of either discretion for a term which may extend to 2 years or with fine or with both।
तो आपको 304 में तो आपको 2 साल सजा किया है।
हाँ, 2 साल सजा किया। That is the maximum punishment is awarded, may extend to 2 years। And 279 also the maximum punishment is 6 months।
गर्ल का एज क्या था?
डिसीज्ड हुआ था,
Deceased.
12 years के लड़के थे।
साइकिल चला रही थी।
हाँ, साइकिल।
एपिलेट को ट्रायल को पढ़िए पढ़िए।
The brief fact is that the case is that on 25/1/2006 30 am, informant's daughter, namely Ruab Fatima, alias Moni, aged about 12 years, was while going to take tuition at Kasim Bazar, then on NH80 near house of Madhav Agrawal, a truck bearing registration number WD654255 being driven negligently run over Moni, resulting in her death. The occurrence was seen by many people.
She was riding the bicycle on a national
No.
highway, NH80। नेशनल हाईवे में बच्चे को साइकिल से छोड़ दिया, 12 साल के बच्चे को। सही है? गलत है ना? तो बस विक्टिम कॉम्पनसेशन कुछ देकर इनका सेंटेंस मांग। फॉगी वेदर था ही। विक्टिम कॉम्पनसेशन कितना दीजिएगा?
मेरा अपना एस्टिमेशन है, जैसे क्लाइंट को जहाँ तक जान रहे हैं इसके प्राधिकार को,
कुछ नहीं, आपके पास ऑप्शन रहेगा, या तो विक्टिम कॉम्पनसेशन देकर आपका कुछ सेंटेंस रिड्यूस हो जाएगा, नहीं तो आप अपना पूरा अपना सेंटेंस कंप्लीट कर लीजिएगा, नहीं दे सके तो।
विक्टिम कॉम्पनसेशन जो पायलट है वो,
विक्टिम कॉम्पनसेशन उसमें फाइन भी है ना, उसको फाइन में कन्वर्ट कर देंगे कुछ
हाँ
पोर्शन,
फाइन भी तो
और
है,
फाइन भी है,
और फाइन है
10-12 साल हो चुका है,
बिल्कुल।
थोड़ा convert
16
कर
साल हो
देंगे।
चुका लगभग 2008 से।
2008 से, तो कुछ कन्वर्ट कर देंगे विक्टिम कॉम्पनसेशन,
ठीक।
यही हो सकता है, कुछ कम कर देंगे आपका सवाल। Criminal Revision Number 764 of 2020. Heard the learned counsel for the parties. This revision has been filed against the judgment dated 27/11/2017, passed in Rajmahal PS case number 14 of 2008, corresponding to GR number 29 of 2008, subsequently TR number 287 of 2017, passed by learned judicial magistrate first class Rajmahal, whereby the petitioner has been convicted and sentenced to undergo simple imprisonment for 6 months for offence under section 279 of IPC. The petitioner has been further sentenced to undergo simple imprisonment for a period of 2 years for offence committed under section 304 capital A of Indian Penal Code. Both the sentences have been directed to run concurrently. The judgment of the trial court has been upheld by the Court of Learned Additional Sessions Judge 1 Rajmahal, white judgment dated 26/2/2020, passed in Criminal Appeal number 60 of 2017. The learned counsel for the petitioner has confined his arguments on the point of sentence. The learned counsel for the petitioner has submitted that so far as the sentence under section 4279 of IPC is concerned, the petitioner has already served the same. In view of the fact that the petitioner is in custody since 19/2/2024 and 6 months has already elapsed. The learned counsel further submits that so far as the offence under section 304 capital A is concerned, maximum sentence has been awarded to the petitioner, and 16 years have elapsed, about 16 years have elapsed from the date of occurrence. He has further submitted that the petitioner at present is 43 years of age, and it has come on record that the present offence is the first offence of the petitioner. The learned counsel further submits that the incident had taken place on 25/1/2008 at 6:30 a.m. when the informant's daughter, aged 12 years, was going to take tuition. The incident had taken place on the National Highway, number 80. Whereby the truck bearing registration number WB65-4255 said to be driven by the petitioner negligently ran over the girl, resulting in her death. The learned counsel has submitted that it has come on evidence that the girl was riding a bicycle on the National Highway. The learned counsel has further submitted that it has also come that the weather was foggy. The Learned Counsel has submitted that, considering the entire facts and circumstances, the sentence be modified to some extent. The Learned Counsel, appearing on behalf of the opposite party state, has opposed the prayer of the petitioner and has submitted that there are concurrent findings of the court and a small girl of 12 years has expired. That's it. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the accident had admittedly taken place on a national highway at 6:30 a.m. on 25/1/2008 when the girl who was age exactly 12 years आया है
12 years.
पोस्टमार्टम एज कितना है
Yes, yes, मैंने ब्रीफ फैक्ट में है पैराग्राफ 3 अपील के जजमेंट में देखा जाएगा पैराग्राफ 3 में दिए हैं.
was about 12 years
हाँ,
was about 12 years of age. It has also come on evidence that it was a foggy morning, but the petitioner was driving the truck in rash and negligent manner. And on account of the accident, the girl expired. This court also finds that it has further come that after the occurrence, the driver fled away from the place of occurrence. Thus, on the basis of materials on record, it stood well established that the petitioner was driving the vehicle, the truck, in a rash and negligent manner on a national highway in which the victim was also riding, victim aged 12 years was also riding a cycle. And it was a foggy morning in the month of January 2018. considering the fact that the incident is of the month of January 2008 and more than 16 years, calculation में गलती नहीं होना चाहिए, 16 साल हो गया ना?
16, more than 16 years.
More than 16 years has already elapsed from the date of the occurrence, and that the petitioner is already in custody, who is now aged 43 years, and the present offence is the first offence. The petitioner has already served the sentence so far as offence under section 279 IPC is concerned. So far as 304 capital A is concerned, this court finds that maximum punishment has been awarded to the petitioner and there is no minimum sentence as prescribed under the said section. It provides for punishment of 2 years, maximum of 2 years, or fine or considering the manner in which the alleged occurrence has happened, that too on a highway where victim girl of just 12 years was riding a bicycle, and considering the totality of facts and circumstances of this case, particularly the incident being of the year 2008, this court is of the considered view that the sentence of the petitioner is required to be modified to some extent for the ends of justice, and though with a reduced to some extent, accordingly the sentence of the petitioner is reduced to 1 year for offence under section 304 capital A of IPC, with a direction to pay with fine of rupees 30,000 to be paid by the petitioner to the किसको जाएगा पैसा?
PW5 informant है.
To the informant of the case, who is the father of the victim girl. The fine amount we deposited before the concerned court within a period of 2 months from today, and the learned court, and upon deposit of the fine amount, the learned court is directed to ensure that the fine amount is remitted to the informant of the case upon due identification. In case the petitioner does not deposit the fine amount within the stipulated time as aforesaid, the petitioner would serve the remaining sentence. This revision is disposed of with the aforesaid modification of sentence.
Passover case cited to Criminal Division 851 of 2020.
I'm for the open number 2, my lord.
The revision has been filed against the order dated 18/9/2020, Your Lords, wherein the learned family court Garva had passed the order of payment of rupees 5,000 to the wife and rupees 1,000 to the minor son. The same order is challenged against this honorable court.
Marriage admitted.
Marriage is admitted, Your Lords. The gist of the marriage is that they are initially they have a love affair among the parties, Your Lords, which was subsequently converted into arranged marriage, Your Lords. And so far as the demand of dowry and all alleged by the government leadership, that was simply denied by the petitioner. There was no demand as it was love marriage, which was subsequently converted into the arranged marriage.
Love marriage में नहीं होता demand.
I had taken the details of that.
Since
And
there
the
was love
first-
marriage, there was no question of any demand. This is what.
That is my defense.
That's
And first, and the first essential of 125 section 4 subsection 4 litigation. The informant is not ousted. She voluntarily left the house of matrimonial litigation. That is also came in the evidence of PW.
voluntarily left.
Yes, yes. For that, this petitioner has also filed the petition under section 9 LDC, where the order had been passed to resume the matrimonial house. But same was denied by opposite party. And I have annexed the order of that restitution also.
Where is that order? Where is that order?
Serial page number 30 supplementary affidavit. IA 3573. Page number 11. That is an extra one.
This was exhibited before the court.
Yes, Your Lordship.
This was passed when? 28th February 2017.
Yes. 20th February 2020. And second, my point for before ladies said that no affidavit to the effect of assets and liability has been considered by
Not
the
required. इतना कम amount fixed हुआ किसी का कोई जरूरत नहीं. Was it your case that she is earning?
no, ladies.
नहीं था ना? काफी.
And I had also filed the supplementary affidavit. See, as per the order dated 3/8/2021 passed by this honorable court also, ladies, I had paid 2,50,000
That's right. That's an interim measure.
interim measure, and the litigation cost I had also paid $20,000.
Very
And still I want to keep the wife with
The
full
mediation
dignity,
has paid.
but that was felt from side
We
of
do not know. We do not know who or at whose instance is paid. We do not record such things, right? Nor the mediation report records such a thing.
and I'm willing to pay 5 lakh rupees and ready to transfer 10 decimal of land which is of my ancestral property to my son, that is opposite party number 2. Despite of that, they are not willing to perform the matter.
You are willing to pay 5 lakhs and transfer how much?
10 decimal of land, Your Lordship. As per the instruction from my
आपको किसने मना किया बच्चे को देने के लिए? दे दीजिए खुशी से.
So,
वाइफ को मेंटेनेंस दीजिए.
रखना नहीं चाहता है, want to keep the wife.
कोई गार्जियनशिप का केस फाइल किया है?
जी,
कोई
guardianship.
गार्जियनशिप का केस फाइल नहीं किया है तो कैसे पैसे से बच्चे को थोड़ी खरीद सकते हैं?
But I am willing to keep. For that I have
आपके
taken-
विलिंगनेस से नहीं होगा ना.
For that I have taken the legal remedy also by filing the section 9 petition.
Section 9 is for the wife, not for the child.
The entire complaint, and there are a series of litigation
आप
among the
अपने-
parties.
अभी डिवोर्स केस आपका चल रहा है,
Yes, let's so after
ठीक है? रेस्टिट्यूशन ऑफ कंजुगल राइट्स के बाद भी रेस्टिट्यूशन ऑफ कंजुगल राइट्स में इसलिए भी ऑर्डर हो गया था क्योंकि उस पर फाइनल फॉर्मेटिंग टर्म्स है, राइट?
दोनों के yes, let's
काफी लिटिगेटिंग टर्म्स है. देयर आर नंबर ऑफ लिटिगेशन पेंडिंग बिटवीन बोथ द पार्टीज. तो ऐसे में आप कैसे एक्सपेक्ट कर सकते हैं कि वाइफ आपके साथ रहे?
I यहाँ पे evidence में भी I used to keep her from different from my family members. Ladies, despite of that, she is not residing with.
कोई बात नहीं, इतना छोटा सा अमाउंट है मेंटेनेंस का.
I am
The
not
wife was
sufficient
actually-
enough to pay that amount, ladies, and I am willing to keep my wife The main basic and scope
नहीं,
behind
there
the
is no scope. इतना acrimonious relationship हो गया दोनों के बीच में. It is not expected. कैसे रहेगी?
the main scope of this act is to keep the matrimonial life happily, to be led by
Happy तो दोनों को happy होना होगा ना कि खाली आप ही के happiness से
no
चले.
both parties.
हाँ, तो
It is the legislation for women, simply for the
ऐसा
women.
कुछ नहीं है. दोनों का happiness होना चाहिए ना. कैसे चलेगा? दोनों की तरफ से एक दूसरे के ऊपर आपका डिवोर्स केस चल ही रहा है, आप उसमें जाके कॉम्प्रोमाइज करिए. परमानेंट एलिमनी पे तब तक इनको मेंटेनेंस. बच्चे के मेंटेनेंस के लिए तो कोई इशू ही नहीं है.
मेंटेनेंस हम ऑलरेडी पेमेंट कर चुके हैं, एफिडेविट में भी दे दिया
तो
है.
ठीक है, कोई बात नहीं, लेकिन इसमें हम लोग कोई इंटरफेयर नहीं कर सकते. बहुत छोटा अमाउंट है मेंटेनेंस का. 4,000 रुपये वाइफ के लिए, 1,000 रुपये बच्चे के लिए. एनहांसमेंट के लिए फाइल करेंगे तो एनहांस भी हो जाएगा.
वो तो 127. बट ये हमारे एफिडेविट में आई एम लिबरल इन दैट मच अमाउंट इज आल्सो वेरी मच.
भाई आपने
burden
कहा
upon
5 लाख रुपए बेटा को देने के लिए तैयार हैं, उसके 10 डिसमिल लैंड उसके नाम से तैयार ट्रांसफर करने के. तो यू आर नॉट अ पर्सन ऑन द स्ट्रीट. तो बीमार नहीं ना है आप.
बीमार नहीं है.
बीमार नहीं, वेल बिल्ट.
बट आई एम रेडी टू कीप माय वाइफ. द मेन
उसके लिए आपको डिवोर्स में प्रोसीड करना पड़ेगा. केस मैनेजर आपका एक बार मीडिएशन जा चुका, फेल हो चुका. आपको क्या बोलना है?
My humble submission, my lord, that as my friend has said, that she has left the house voluntarily, it is not the fact. She was beaten, assaulted, abused, dowry claim was there, father was called upon, and thereafter she has not left the house voluntarily. Secondly, my friend is said that he is a labor. In page number 18 of the
Forget about labor.
he has got poultry farm, shops and clothes for 160,000. And if my friend is that she is not desirous to live with me, for that 498 is there, cognizance is there, so she is not in a
So 498 matter is still pending.
still pending.
At the time of restitution of conjugal rights,
Final form was submitted. There are
Only final form was
yes,
submitted.
yes, my lord. Protest petition was filed. That was inquiry conducted, witnesses examined, prima facie case was made out, and he process issued, and he appeared. My lord. So in such a case, the order is legal, proper, valid, and within the ambit of law, and pray that revision may kindly be dismissed.
there is finding at page number 10 of that with regard to that on careful consideration of entire fact and
उसके ऊपर
material.
ऊपर पड़ी Exhibit 1 was the final form submitted. Right?
Copy of LCR.
नहीं, Exhibit 1 यही तो पेज नंबर 19 में टॉप में लिखा हुआ.
Yes. In your brief.
उसके पहले देखिए, the petition also proves false. You see, it took into consideration that a false case was instituted, and the final form was submitted, and now the protest petition has been filed. That case is going on. फर्क हो गया ना, अब तो litigating terms में हो गए ना आप लोग दोनों.
Litigating
आपने भी तो केस किया है ना.
from both parties there.
From both parties, they are in litigating terms. For the learned counsel for the parties, this revision is directed against order dated 18/9/2020, passed by learned Principal Judge Family Court Kadwa under section 125 CRPC in original maintenance case number 30 of 2018, whereby the petitioner has been directed to pay maintenance to the opposite party number 2 wife at the rate of ₹5,000 per month, and to the opposite party number 3, the minor son, at the rate of ₹1,000 per month from the date of application. The learned counsel for the petitioner submits that the marriage is not in dispute between the parties, rather the marriage was a love marriage which ultimately took the shape of an arranged marriage, and therefore there was no question of demand of any dowry. The learned counsel submits that the petitioner, that the opposite party number 2 had filed a false case for alleged offence under section 498 capital A of Indian Penal Code, and in fact she had voluntarily left the matrimonial home. He has also submitted that the petitioner had also filed a petition for restitution of conjugal rights, which was decreed by the order dated 20th of February 2017. The learned counsel further submits that the petitioner is still ready to keep the wife and his child. He has submitted that a petition seeking divorce has been filed by the petitioner, which is pending. The learned counsel has further submitted that he is ready to keep the wife and the son, and he has taken instruction from his from the petitioner, who is ready to pay rupees 5 lakhs and transfer 10 decimal of land in favor of the opposite party number 3, the son. The learned counsel, appearing on behalf of the opposite party number 2, has submitted that the matter was sent for mediation, and ultimately the mediation has failed. A failure report of the mediation has been received by this court. He has further submitted that the opposite parties do not have any source of revenue, and a meager amount of rupees 5,000 for the wife and 1,000 for the minor son has been fixed. He has submitted that after the final form was submitted by the police, a protest petition was filed, and in which cognizance has already been taken, and thus the criminal case for the alleged offence under section 498 capital A is pending against the petitioner. He has also submitted that there are case and counter case between the parties, both of civil and criminal nature. The learned counsel has further submitted that the impugned order has rightly been passed and the same does not call for any interference. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the marriage between the parties is not in dispute, which had taken place way back in the year 2013, and the child was also born out of wedlock. This court finds that the petitioner had filed her application on 22/2/2018 seeking maintenance. By asserting that there was a demand of rupees 1,50,000 from the side of the petitioner immediately after she went to her matrimonial house, but when her father was unable to meet the demand, he was assaulted and was thrown out of matrimonial home. There were several panchayati held, and on 21/3/2016, the petitioner took his wife and son with him, but his behavior did not change. And ultimately, she was assaulted by holding her hair and assaulted on her belly. And the petitioner had registered, and the wife had registered a criminal case being GR case number 1231 of 2016, in which final form was submitted and a complaint case was instituted, subsequently bearing number 1840 of 2016, which was pending for evidence. It further appears that one case was filed by the petitioner seeking the restitution of conjugal rights under Section 9 of the Hindu Marriage Act, which was numbered as NM case number 29 of 2016, and thereafter it was allowed on 20th February 2017 by observing that the police had conducted investigation and final form was submitted. It further appears that another criminal case has been instituted by the wife, being criminal petition number 30 of 2017 on 8/3/2017, that is after the passing of the order of restitution of conjugal rights, and one case has been instituted from the side of the petitioner husband and the father of the petitioner has also filed a case bearing GR case number 1398 of 2017. It appears that there are case and counter case. There are cases, both criminal and of civil nature, between both the parties, filed by both the parties against each other. This court further finds that the learned court, after taking into consideration the evidences on record, this court finds that on behalf of the wife, she had examined herself and her father, and on behalf of the petitioner, altogether 3 witnesses were examined, including himself and his father and 1 villager. Number of documents were also exhibited, whose details are as under para 4 number. This court finds that the learned court has scrutinized the materials on record and has also recorded that during the trial of the maintenance case, 2 cases were filed, one by the husband and one by the wife against each other. the court also recorded that a divorce case was also pending, which was filed at the instance of the husband. The learned court, after considering the entire materials on record, has ultimately awarded maintenance of rupees 5,000 to the wife and 1,000 to the son. During the course of hearing, the learned counsel for the petitioner has fairly submitted that he has not filed any petition for guardianship so far as the son is concerned. This court finds that the learned court has passed a well-reasoned order, and even after passing of the order of restitution of conjugal rights, there have been case and counter case between the parties. Case and counter cases. There have been criminal case filed by both the parties against each other. In such circumstances, the learned court has rightly passed the order of maintenance, and this court finds no illegality or perversity in the given order. Accordingly, this petition is hereby dismissed.
Professor, my submission that without considering the findings of Rajneesh versus Neha, the quantum has been decided.
Okay. The learned counsel has also submitted that no affidavit in terms of Rajneesh versus Neha was filed. This court is of the considered view that only a meager amount of maintenance has been fixed, and in such circumstances, this court is not inclined to interfere with the infant. And it is not in dispute that the wife and son do not have any source of income.
Also, case item 3, Criminal 1168 of 2017.
First minute, 2015 minute. Paragraph. Paragraph 10. It is the case of washing under 482. Paragraph 10. So far as the issue regarding the registration of FIR under section 353 IPC is concerned, it has been seen whether by posting a comment in the Facebook page of the traffic police, the conviction under the section could be maintained. Before considering the materials on record, we are usefully referred to section 353, which reads as follows. Now, a reading of the above provisions shows that the essential ingredient of the offence under 353 are that the person accused of offence should have assaulted the public servant or used criminal force with an intention to prevent or deter that public servant from discharging his duty as such public servant. By perusing the materials on record, it appears that there was no force used by the appellant to commit such an offence. There is absolutely nothing on record to show that the appellant either assaulted the respondent or used any criminal force to prevent the respondent from discharging his official duty. taking the uncontroverted allegations, in our view, the ingredients under section 353 is not met out. Now, the second mallet one, Punjab and Haryana, I was replying. Para 7 minutes. A bare reading of the above section clearly shows that if a public servant, while discharging his duty, is attacked or any injury caused to public servant in discharge of his duties, or when any public servant prevented or deterred from performing his duty, or when any public servant assaulted or any criminal force used by against the public servant while he is executing his duty as a public servant, then only the above offence would attract it. It is not the case of the prosecution that the accused caused hurt or assaulted the constable Devinder Singh while he was performing his duty as a public servant, or with intent to prevent him or deter from the discharging his duty. I am therefore of the opinion that the necessary ingredients to attract 332, 333, 353 is not present in the present case. The learned additional session judge has not considered this aspect of the matter. The learned session judge referred to the Supreme Court judgment in Munu Manaya versus State of Gujarat reported in 1979 4 SCC 717. But that decision is not applicable in this case, as in that case the driver of the bus was prevented from entering into the bus to drive the bus, which is in his duty. Therefore, on the facts of this case, it has been held that the public servant was preventing from his duty, namely plying the vehicle, but such is not the case in the present one. And criminal force, if I am stopping somebody from moving into some manner, then it is the force comes, my lord. If I am not stopping, then force is not comes, and if it is not force, then criminal force automatically will not be there, my lord. So here the specific allegation is that, my lord, I have entered the room, I have sat in the room, and I was asking that why the death certificate has not been provided to him. And thereafter, my lord, neither I have assaulted, nor I have stopped the public servant from going into any motions or have tried to do anything, my lord. So, and my lord, as per the allegation, my lord, he was sitting in his chamber. His case is to dispose of when he will sit in the court, my lord. So there are certain cases, my lord, where a constable is there going in the village, and at that time a scuffle took place. My lord, it can be 307 or anything, but not 353, because at that relevant point of time he was just a constable wearing a dress will not attract 353. It should be that he has been stopped from doing official duty. Now, my lord, one judgment of recent judgment of Bombay High Court, my lord. Para 9 onwards, my lord. Proper deliberations. From 7 only, the deliberation has been given. In paragraph 7, the 353 has been defined. Para 8, that the plain reading of the provisions indicate that the first and foremost requirement for attracting the rigor of this provision is that the public servant must be discharging his duty. Needless to say that such duty was lawful. Unlike in some other provision, the purported discharge of duty by public servant is not contemplated herein. Hence, for making provisions applicable, the discharge of lawful duty is a condition precedent. Further, in order to attract the said provision, there must be an assault or use of criminal force against the public servant to prevent or deter that person from discharging his lawful duty. Section 349 of the IPC defines criminal force. Well, thereafter criminal force has been discussed, that I have already read. thereafter, my lord, from the above definition, para 10, my lord, clearly shows there can be set force to use only one person, one makes another to cause motion, change of motion, or cessation of motion in one of the three ways expressly provided therein. That is, by his bodily power or by disposing any substance in such a manner that the motion or change or cessation motion takes place and inducing any animal to move, to change its motion or to cease to move. In absence of adoption of any of the three ways, or in absence of causing motion, change or cessation thereof, the above definition would not tract. Criminal force has been defined in 350, indicates that whoever intensely uses force, first it should come to force, my lord, to any person with that person's consent in order to commit any offense or intending by use of such force to cause or knowing to be likely that by use of such force he will cause injury, fear or innocence to the person to whom the force is used, is said to use the criminal force to that other. Perusal of the first information report shows the applicant abused and threatened the respondent number 2 and rushed on his person. There is no allegation against the present petition that he caused the respondent number 2 any motion, change of motion or cessation of motion with the use of bodily power. Thus, on the face of it, it is not wherein any force is used
How
by.
are force and criminal force interconnected?
My lord, first, my lord,
Is it necessary that to constitute a criminal force, there has to be a force?
Yes.
From where do you say this?
from the definition itself. So, let us see, kindly see the definition.
The concept of fear or
Whoever
annoyance.
intentionally uses force.
No. The concept of fear or annoyance is totally missing in force. In the definition of force, the concept of fear or annoyance is completely missing.
So, if fear and annoyance, then it becomes a criminal force.
That's. If
But-
there is a fear or annoyance, then it becomes a criminal force.
Criminal force. But prior to that, my lord, it has
If
to
on
be a
the
force.
basis of a verbal statement made, a person suffers some fear or annoyance.
Lord, that
It
Bombay
will
High Court
not
has discussed, my lord. That point, if Lordship sees that has been discussed. Because on the basis of illustrations, my lord. That has been discussed. The above definition, my lord, if
Yes, para 14.
para 14, my lord, yes. The above definition indicates that whoever makes any gestures or any preparation this is assault, my lord, or any preparation intending or knowing it to be likely that such gesture or preparation will cause person to apprehend that he is about to use the criminal force, to that person is said to commit an assault. According to the explanation thereto, mere words do not amount to assault, but the words which a person uses by giving to his gestures of preparation such a meaning as the case may make those gestures amount to assault. For the instant case, illustration A and C would be relevant to take into consideration. These illustrations show that what sort of gestures are contemplated in order to constitute to be an assault, and they indicate that there has to be a clear intention appearing from the gesture that the person is intending to cause to believe that he is about to strike other. My lord, if I would have pointed out a finger to that public servant, that means that gesture is this, my lord, that I am trying to use, I may use a criminal force, because of which he may feel intimidated But that is also missing in this case. And prior to this, my lord, in para 13, the force and criminal force has also been deliberated, my lord. Para 11 says, my lord, the criminal force, whoever uses force to any person without that person's consent in order to commit an offense or intending to use such force to cause or knowing it likely that by use of such force he will cause fear or annoyance to the person to whom the force is used is said to presume the first that shows that the applicant abused and threatened and rushed on his person. There is no allegation against the present applicant that he caused the respondent number 2 any motion, change of motion, cessation of motion with the use of bodily power. Thus, on the face of it, it is not a case wherein a force has been used by the applicant and consequently the application of criminal force does not arise. But here, if I would have at least shown a finger, that gesture would have come within the ambit of assault. Or criminal force, my lord, if I would have pushed him, then I have tried to move him from in a different motion, my lord. That is also, it was just a hot talk, hot exchange of words between the public servant and the accused persons. So, my lord, if there is only a hot talk, then neither force comes, nor criminal force comes, nor assault comes. So, these three ingredients are the precondition, coupled with the fact that I have stopped him from discharging using this force, criminal force or assault. Then 353 will come into play. Good. Now, my lord, one more deliberations, proper deliberations have been made by relying all these judgment of Honorable Supreme Court, Punjab and Haryana High Court and Kerala High Court. That is in the judgment of recent of 2023, my lord, Madhya Pradesh Jabalpur High Court bench. Here it was an appeal, my lord. Since it was tried by an MP MLA court, so it has been heard by the High Court. Here my case and this case was more or less because here also he was saying that he was a congressman. For that reason these things has happened. Let us see, kindly see para 2, the facts of the case. And then para 6 is the again part of the story, my lord, that as per the prosecution, appellant got into heated argument with the police official, alleged that the police is registering a false case at the instance of local MLA just to malign the reputation of the appellant by keeping the weapons in the car and arresting the innocent person in the police station. The appellant abused Ram Swarup Pandra, who is the complainant, and lodged FIR against the appellant, saying that he has given undue favor to Hindu Tiwari. As such, despite registration of offence under 307 against him, he was granted bail within 2 days, as Sri Pandra, after investigation, provided a very weak case against Hindu Tiwari. As per the prosecution, the appellant picked up a stool and tried to assault the complainant and also abused him. Then the FIR got registered under such and such. My lord, here it was not under 353. But ultimately the conviction was under 353. The deliberation starts, my lord, from para 16. Then Manik Taneja's case has been discussed by the Supreme Court that I have just read, my lord, in para 22. And then, my lord, a case of Kerala High Court has been discussed in para 22. Further, in the case of PB Mathai Supra, the Kerala High Court also considered this aspect and dealing with the material ingredients of 353 and also observed as under. Section 353 deals with such and such, my lord. A bare reading of the above provision, it would clear that in order to attract the offence, the prosecution is required to establish there was an assault or a use of criminal force, and such assault or use of criminal force was made on the public servant while he was acting in execution of his duty, or with an intent to prevent or deter him from discharging his duty, or in consequence of anything done or attempted to be done by him in discharge of his duty. There is no doubt that the second respondent is a public servant. At the time of alleged incident, she was discharging her office. But the crucial question, whether the petitioner has assaulted the second respondent or used any criminal force, and whether the alleged act was done by the petitioner with an intent to prevent or deter the second respondent from discharging his official duty. The word assault has been defined under 351, which reads as follows. Reading of 351 IPC would show that the victim must apprehend that he who makes the gesture of preparation was about to use criminal force to the victim. Then what criminal force has been defined in 350 and what force has been defined in 341. Then para 13, my lord. In the case in hand, the prosecution has no case that the petitioner used any force on the second respondent. On the other hand, the case of the prosecution is that after entering in the office room of the petitioner, the accused asks as follows: who asked you to enter into my property? Who is your authorized officer? Who gave you the authority to enter in my land? Apart from uttering these words, there are absolutely no use of force or even an attempt to use force. Apart from the vague allegations in the official time of second respondent was lost on the account of alleged acts of the petitioner, there is no specific allegation that the above mentioned words were uttered with the petitioner with an intent to deter the second respondent from discharging her duty. Now in Jaspinder Singh that I have read, my lord, that the Punjab and Haryana High Court, my lord, has again that has been deliberated, my lord, and then in that only in para 7 of that judgment has been quoted. If a public servant while discharging his duty is attacked or any injury caused to the public servant in discharge of his duties, when any public servant prevents or deterred from performing his duties, or when any public person assaulted or any criminal force used against the public servant while he was executing his duties as a public servant, then only the above offence would attract. It is not the case of the prosecution that the accused caused hurt or assaulted the constable Devendra Singh while he was performing his duty as a public servant, or with intent to prevent him or deter him from discharging his duty. I am therefore of the opinion that the necessary ingredients are 332, 333 and not present in the present case. The additional session judge has not considered the aspect of the matter. The learned additional session judge referred to the judgment of the Honorable Supreme Court in the case of Munmaya versus State of Gujarat 1979 4 SCC, but that decision is not applicable in the facts of the driver of this bus was prevented from entering the bus to drive the bus, which is his duty. Therefore, on the facts of that case, it has been held that the public servant was prevented from discharging his duty, namely plying the vehicle. But such is not the case in the present case. There is no allegation anywhere in the complaint that the police constable was prevented or deterred from performing his duty. There is no allegation that he was hurt while performing his duty. Performance of duty already been done by him by delivering dark at various places. He was coming back to the police station after performing his duty simply because the police constable happens to be a public servant. It cannot be said that he is discharging his duty. It depends upon the facts whether a public servant can be said to be discharging his duties and whether the offences have been committed when the public servant has been discharging his duty. It is not even the case of the prosecution that the accused had knowledge that the constable was performing his duty. Therefore, it cannot be said that the accused, with an intent to prevent or deter the complainant from discharging his duties, caused injuries to him. It cannot be said that the accused caused hurt to the constable while he was discharging his duty. I am therefore of the opinion that section 332, 333 and 353 is not attracted in this case, but the fact remains that his teeth has been broken, my lord, so it has been remanded back to the concerned trial court that to see that whether which offence is made out. And thereafter these judgments, my lord, the 23, my lord, here entered the paragraphs have been quoted. चेंबर के अंदर इंद्रजीत बाबू द्वारा सीपी टीवी बाहर के उपरोक्त विषयों को लेकर चर्चा कर रहे थे. सीपीआई आरएल साहब स्पष्ट उनके सामने बोल दिया था कि 6 लड़के को जो गिरफ्तार हुए वो है उनके पास हथियार प्राप्त हुआ है, जब्त किया गया है, जो कार्रवाई की है ये की गई तो इंद्रजीत सिंह बबलू गुस्से से चेंबर से बाहर निकला और अपने साथी थानेदार के साथ फोर्च में नीचे बैठा था। मुझे देखते ही आरोपी इंद्रजीत सिंह बबलू गुस्से में आकर बोलने लगे कि तुम सचिन सर तुम्हारे भाई को मामले में सख्ती से कार्रवाई नहीं करने के कारण आरोपी इंदु कुमार तुरंत न्यायालय में जमानत हो गए। हम तुमने भाई को इन्हीं कार में बैठे हुए हमारे लड़के को भी हथियार सहित गिरफ्तार किया जबकि उनके पास हथियार नहीं था। वहां पे गाली गलौज देते हुए तुम सचिन सर मुझे गाली सुनने का बहुत खराब लगा। इंद्रजीत सिंह बबलू गुस्से में थे। पास में लड़की का स्टूल पड़ा हुआ था, उस स्टूल से अपने हाथों में उठाया और मुझे मारने के दौड़। अगर इसी समय टीआई बाहर आवाज सुनकर बाहर नहीं निकलते और इंद्रजीत बाबू पकड़ते नहीं तो अप्रिय घटना हो जाती, मेरी हत्या भी हो सकती थी। And thereafter, my lord, deliberations have been made, my lord. And then the 27, my lord, is the relevant. In view of the aforesaid, the law laid down by the Honorable Supreme Court in the cases cited above and after examining the definition of assault and criminal code as mentioned above, also the statement of the complainant and other witness produced, I am of the considered view that the prosecution has failed to establish that there was an assault or use of criminal force by the appellant and such assault or criminal force made on the complainant while he was acting in execution of his official duty. The prosecution has failed to give any reasonable explanation, and that is not my case, my lord. Trial failed to appreciate the aspect, the matter failed to any finding in this regard, but at the cost of repetition, it is reiterated here that the witnesses produced are all interested witnesses and not the independent, hence the testimony is doubtful and cannot be relied upon. The statement of complainant Ramswarup itself reveals that at the time of incident he was not performing any official duty. Nobody restrained him from discharging his official duty or assaulted him. However, if the statement of any of the witnesses records after 2 years he states contrary to the statement of the complaint, he cannot said to be a trustworthy witness and his testimony is doubtful and cannot be relied upon. Grave mistake in recording statement after a long delay of 3-4 years. On the basis of such statement, which is not corroborated with the statement of complaint, the finding of conviction by the trial court cannot be appreciated and approved, and hence this court allows the appeal mainly on the ground that it has failed to establish the material ingredients of 353. Now, the deposition of PW4 पैरा 14, ये तीनों अभियुक्त ने कहा कि तुम बहुत कानूनची बनते हो। ये बात DN चौबे भी बोला था पिटिशनर को बिफोर योर लेडीशिप। बारे गला में बिन खानी खास सफी अहमद एवं गवाही देने वाले व्यक्ति जिसका नाम नहीं बता सकता हूँ, वहाँ मैं था, उसको पहचानता हूँ पर नाम से नहीं जानता हूँ। मतलब if the public servant was doing any public duty, my lord, then what he has stated that he has to dispose of 13 cases, my lord, and not even a single staff was present at that chamber, my lord. And admitted, if lordship sees the deposition of the IEO has stated that the chamber is beside the place adjacent to the chamber where the court is being held by the executive magistrate. So admittedly, he was not sitting in the court; he was sitting in his chambers. And if in the chamber somebody is entering, my lord, where police and other officials are there, that means that in the chamber he was not doing any public duty, my lord. When he will move from the chamber to the concerned close where the lawyers and others were sitting, my lord, for disposing of the cases, then he can said to be have done a official duty. And not even a single person who was present in the at the time of occurrence has been examined. All the 3 witnesses who have been examined are hearsay witnesses, were there orderly, even the orderly was not present at the chamber. And with regard to this, that Harbir Singh only on para 11, my lord. And this is on criminal jurisprudence. that burden of proving the case beyond a lies on the prosecution and never shifts. This is settled principle.
Yes, what do you have to say?
The concurrent finding by both the courts, his appeal was dismissed. PW4 has fully supported the prosecution case. Apart from PW4, PW1 has also supported the peon of this person.
You see, there are concurrent findings.
Yes.
He also does not dispute that there are concurrent findings.
And
But show us the concurrent finding on use of criminal force.
Criminal 353 says assault or criminal force.
That's it.
To deter public servant from discharge of his duty. Whoever assault or use criminal force to any
So it
person.
is assault or criminal force or both.
Yes.
Yes
Or-
means
or-
I just
assault
want to
is
know-
also 353.
That's fine. The 353 section says assault or criminal
criminal
force. So is it your case that he was assaulted or a criminal force was used? Where is that finding by the courts concerned that there was a criminal force or there was an assault? Show us the finding from the impugned order.
We'll see.
Impugned order नहीं है आपके पास?
No, हम यहीं से देख
Impugned order भी नहीं है आपके पास?
no file is there because it is of 2017 old file.
So you are so casual about your case.
No, yeah, let's see.
आपको ये-
I've
आपको ये-
seen from the court's file in the
So
morning.
you are not able to, you have just seen it. ऐसा मेमोरी तो हम नहीं देखे हैं किसी का कि देख लिए एक बार तो बस हो गया काम खत्म. नहीं, आपको फाइल नहीं चाहिए कोई केस बहस करने के लिए.
फाइल चाहिए.
हाँ तो फिर बिना फाइल के ही बहस करते हैं आप.
नो इलेक्ट्रिसिटी हम नोट किए हैं कुछ उससे ingredients.
आप जो नोट किए हैं इतना कैजुअल है तो हम लोग क्या पढ़ा. यू डिफेंड योर केस. क्या चाहिए आपको?
And his sentence already committed to 6 months.
दैट्स राइट. सेंटेंस पे तो बहस ही नहीं कर रहे.
Para 5 of criminal law. On perusal of the evidence available on record, it is clear that except the informant, all 3 witnesses, PW1, 2 and 3, are orderly peon posted in the office of SDO Chas, among whom PW1 Bhavani Das is orderly peon posted with the informant himself with, while PW2 Munna Singh was posted as orderly peon in the office of SDO Chas, and Vakil Singh is posted in the establishment branch of SDO office. Vakil Singh is PW1 Bhavani Singh has clearly stated that hearing the roar from the chamber of his officer, he entered into the chamber and saw that Barmali Chaudhary, DM Chaube and another person were quarreling with him and using filthy language. On the direction of his officer, he went to call the police from the office of SDO Chas, and the police came and tried to persuade them, but even then they do not stop quarreling, and then the police of Chas police station was called. The witness has also stated during cross-examination in para 6 that all these 3 accused persons were regularly visiting the office in relation with the death certificate. PW2 Munna Singh, the orderly peon of established branch, has also stated in his examination in chief that hearing the uproar, he went to the office of the executive magistrate Sri Manoj Jaiswal, and thereafter in his chamber, where the executive magistrate said him to call the police from the DYSP office who arrested the accused person. Though the witness has not stated about the quarrel or any filthy language used by the accused person, but he has clearly stated that he heard the uproar and then went there. These things established the prosecution case. But he clearly stated that he heard the uproar and then went to there. And then on his direction called the police. In para 6 of cross-examination, the witness has already stated that the establishment branch is situated just in front of the office of Sri Manoj Jaswal, from where his chamber is visible. The witness has also stated in para 8 that when he reached there, he saw several people gathered there. PW3 Vakil Singh is not the eyewitness of the occurrence, but he is here as a witness. This witness has stated in examination in chief that he heard that three persons quarreled with executive magistrate Manoj Jaswal. The witness has stated further that the quarrel took place in the chamber of the officer. Thus, on perusal of the statements of the PW 1, 2 and 3, it is clear that some occurrence of quarrel had taken place in the chamber of informant executive magistrate Manoj Jaswal, which was witnessed by his orderly Bhavani Das. Bhavani Das has clearly stated that when he entered into the chamber of his officer, he saw one Mali Chaudhary, D.N. Chaube and one another quarreling with the officer who were using filthy languages during quarrel. PW2 has also heard the uproar and went on the place of occurrence and saw mob gathered there. Both the orderly peons PW1 and 2 have stated that they called the police. The testimony of these witnesses may not be discarded as they are the usual witness who were posted as orderly in the office of the informant as well as in the office of the KO. These witnesses have fully corroborated the fact that uproar had taken place in the chamber of informant, and PW1 has clearly stated that he saw the accused persons quarreling with the officers who were using filthy languages. The informant Manoj Jaswal has also fully supported the case and has stated that D.N. Chaube, president of Congress Party of Charlestown, one Mali Singh, ex-block Pramukh, and one Ramlal Singh came in the office, and D.N. Chaube asked him why he has rejected the application to issue the death certificate of his man. When he explained that there is difference of 9 months in the date mentioned in funeral certificate and in the application form, and the reason of the death paralysis for which medical certificate is required, D.N. Chaube sat on the chair and started abusing him. He prevented them, but they did not stop, and then he called the police and informed the matter to Chas police station and submitted the written report. The informant has identified the form 4, which is an application form for the issuance of death certificate. The funeral certificate and the affidavit annexed with it are marked Exhibit 2, 3 and 4 respectively. On perusal of the form, it is clear that the application was filed for the issuance of the death certificate of late Sandhariya Devi, wife of Ramlal Singh, which is one of the accused of the case. In the application of the date of death is written 19/4/2002, while the funeral certificate was issued on 7/1/2003. The witness has stated in his examination in chief that the reason of death is shown paralysis, for which the medical certificate was required as per rule. During cross-examination, the executive magistrate had stated in para 36 that he has sent letter for the verification of funeral certificate, and it was informed by the disciples of Margat Baba that his funeral certificate was not issued by them. Thus, it is also clear from the documents that the information of death of Ramlal Singh was submitted before the informant for the issuance of death certificate, which was refused by the informant, giving the reason that it was against the rule, and the funeral certificate was issued after the gap of 9 months of the date of death. Among the appellants, Devendra Chaube is the leader of Congress Party, while Banmali Singh Chaudhary was ex-block Pramukh of Chas block, and Ramlal Singh is the person affected by the non-issuance of the death certificate of his wife, late Sandhariya Devi. From the evidence of this witness, the fact is well proved that executive magistrate refused to issue the death certificate of the wife of appellant Ramlal Singh, for which he was being pressurized by the appellants who were the leaders. It has become trend in the society that leaders put pressure on the officers to do legal and illegal work on their will, and in case of refusal, they use all the weapons to get the desired result. To scold, abuse or assault the public servant by the leaders is not uncommon in the society. In this case, too, the appellants who are the leaders abused and quarreled with the executive magistrate, who is a public servant. The informant has clearly stated that they said him such and such, kanunchi banta hai, and quarreled with him and deterred him for doing the office work. The witnesses have fully supported the case of prosecution. PW1 has clearly stated that he saw the accused person
आप कहाँ पढ़
quarreling
रहे
with
हैं?
the
कहाँ पढ़ रहे हैं? पैरा नंबर?
para 5 of appellate
Appellate
court
court?
judgment.
ठीक.
It is from page number
That's
internal
right.
page 10.
I've got it.
I am on internal page 13. The witnesses have fully supported the case of prosecution. PW1 has clearly stated that he saw the accused person quarreling with the officer using filthy languages, and PW2 has also stated that he heard the uproar and went to the chamber of Sri Manoj Jaiswal and saw mob gathered there. The evidence is sufficient to prove the fact that the accused persons quarreled with the executive magistrate and abused him in furtherance of their common intention for non-issuance of that certificate by the executive officer, and the offence under section 353 and 504 is well proved against the appellants beyond all reasonable doubt. Non-examination of bench clerk and other concerned person is not sufficient to disbelieve the case of prosecution.
इसका पार्ट डिक्टेशन लिया है मुकुल जी ने, ठीक है, तो ये थोड़ा सा डिक्टेशन उनको हैंड ओवर कर दें, ठीक है. The learned counsel for the petitioner.
And goal of section 353 is to protect the dignity and authority of public servant.
In the entire finding, it has nowhere been stated that they have used any criminal force or anything to do.
The learned counsel for the petitioner has relied upon the following judgments. Number 1, bracket 2015, bracket row 7, SCC 423. Manik Taneja and another versus State of Karnataka. Para 10.
And one more thing, Your Lordship, he was executive magistrate. No, court work is not only his work. इसके evidence में आया है is law and order and other works are also his public duty.
Nowhere he has stated that he has been deterred from doing that law and order part. In the evidence, nowhere. Then nowhere he has stated that I have been deterred because of this act. I have been deterred for doing this. He is saying
Para 10.
court work. He is
Ex-
because I have to dispose of certain cases.
Number 2, second judgment is judgment passed by Honorable Punjab and Haryana High Court, reported in 1995 SCC on 9 PNH 157. Para 7. Then जजमेंट ये है 2023 SSC ऑनलाइन बॉम्बे 818 आमिर खान वर्सेस स्टेट ऑफ महाराष्ट्र, और वो पंजाब एंड हरियाणा का पार्टी का नाम है जसविंदर सिंह वर्सेस स्टेट ऑफ पंजाब. इसमें पैरा 7 to 15 और judgment passed by Honorable Madhya Pradesh High Court in criminal appeal number 5697 of 2019. Paragraph 16 to 20. That should be sufficient.
16 to 20, and thereafter 22 to
16 to 20.
and 22.
16 to
20 to 24.
16 to 23.
23.
The learned counsel appearing on behalf of the opposite party state has opposed the prayer and has submitted that there are concurrent findings recorded by both the courts. By holding the petitioner guilty, she has submitted that the informant of the case was an executive magistrate who was discharging his duty even in his chamber, even in his chamber, when the accused persons entered in his chamber and committed the crime. बाकी लोगों का क्या हुआ?
बाकी लोगों को कोई आईओ है?
नहीं, बाकी लोगों का क्या हुआ? They were convicted, not convicted.
All have been convicted.
They are not moved.
I am not aware that whether they have moved.
ये देखिएगा तो इस पर्टिकुलर केस से और भी कोई केस फाइल हुआ है? ऐसा अनअवेयर मत बनना चाहिए, सही नहीं है। आप अनअवेयर तो नहीं हो सकते ना? You have been engaged. This is the basic question
Yes,
which
ma'am.
you would have asked. इसका जरा और कनेक्टेड देखिए, ये जीआर केस नंबर इतना सा आपको भी नहीं पता, इनको तो नहीं पता है, आपको भी नहीं पता। The learned counsel has specifically referred to paragraph 5 of the appellate court's judgment and has submitted that the basic ingredients for committing offence for which the petitioner has been convicted has been duly satisfied. एक आप कहीं पढ़े थे डेटर, वही हम खोज रहे हैं, हम मिल नहीं रहा।
ये 353 नहीं है, whoever assaults or uses
नहीं लैंग्वेज में नहीं, वो फाइंडिंग में आप
Finding में debtor.
एक वर्ड आप पढ़े थे डेटर, इसी उसी समय हम आपसे पूछे थे कि आप कहाँ एग्जैक्टली पढ़े।
पेज नंबर 30
13 अपील, अपील कैसे हुआ? 13/2005 क्या हुआ? पेंडिंग है, इसमें कोई अपील है नहीं?
Three persons appeal has already been dismissed by the session judge. Revision ही होगा, appeal का।
अपील तो नहीं हो सकती।
ये तो magistrate tribunal offences में।
अपील हुआ था, डिसमिस हुआ।
नहीं नहीं, वो नहीं बोल रहे, इसका नहीं पूछ रहे हैं। अपने हाई कोर्ट में को एक्यूज का केस फाइल हुआ है, हाई कोर्ट में को एक्यूज का केस। The learned counsel submits that the appellate court has clearly recorded that the informant has clearly stated that the accused said, साले बहुत कानून की बनता है, inverted commas, and quarreled with him and deterred him from doing the official. The learned counsel submits that both the judgments are well discussed and it does not call for any interference. She has submitted that to attract offence under section 353 IPC, criminal force or assault is required to be established, and in the present case, the basic ingredients have been duly established. Very
He also includes debtor that person from discharging his duty.
The learned counsel submits that Section 353 of IPC uses the term debtor from discharging official duty. CAB.
I am not argued on sentence, my lord. But now they are aged about, my lord, quite an old person and 6 months, my lord, and they have, see on and the period, the trial they have faced for the course of the trial. If any manner that sentence, if
In
set off,
response, the learned counsel for the petitioner has submitted that the petitioner, that without prejudice to the submission on merit, the petitioners have faced long drawn case right from the year
right from the year
2005.
2005, and therefore, though the appellate court has taken a lenient view and reduced the sentence
to 6 months.
but to 6 months, but it may further be considered for reduction of sentence. He has submitted that there is no minimum sentence.
Maximum sentence is there.
There is no minimum sentence prescribed under the offence for which the petitioner has been convicted. The counsel for the state has opposed the prayer for reduction of sentence.
Yes, because it is already committed to 6 months.
She has submitted that the appellate court has taken due care by reducing the sentence to 6 months. The trial court had given the sentence of
2 years.
Maximum. Always.
कोई केस नहीं है इन्हीं का एक CRMP मौका नहीं
But I will find it out and immediately send it to the.
find it up.
Sorry, my lord.
Condition item 7, Condition 757 of 2016.
ये जब आप आपको देंगे ना जितना जितना सेक्शन है 353, 448, 504 ये सारा इसमें जितने सेक्शंस मेंशन 349, 350, 351, 352 हाँ ये सारे हमको इसकी जरूरत है ये सारे हमको देंगे और जो जजमेंट्स के जो पैराग्राफ्स हैं उसको भी एक जगह टेक द हेल्प ऑफ गोरंटी ये है your
Item
petition.
7.
On the last date also you were absent. The court has observed that you are not taking any interest in the case. And now you are seeking passage. Who is the arguing counsel?
Mr.
This is check bouncing matter. Exemption from surrender आपको मिल गया था? Yes? नहीं पता. आप कौन हैं?
For the estate house.
Who is for OP number 2? Exemption आइए pending है ना?
Yes.
हम्म? बुलाइए कब तक आएंगे? victim delivered. Service हो चुका. ये for petitioner है drafting. Passover है बुलाइए.
Item 8, Pinarjan 836 of 2016.
Yes, petition.
In 2016, this petition was enlarged and paid. Now it has come under the heading of permission.
So,
To my understanding, the victim has also cleared it as a party.
But I'm already appearing for OP number.
it's already appeared.
Yes, I'm already appearing.
Are you arguing?
But the date will be fixed for the final disposal of the same.
Though, Lord, I'm not having the copy of memo. Lord.
You can fix the date for tomorrow.
A direction may also pass for supplement. We'll procure it from the office LCR.
LCR perhaps not, it is coming under the heading admission, so LCR might not be here.
LCR is already here.
We'll procure a copy from the office.
No, that is 2016. This matter is pending.
Therefore,
The records are here. You can peruse the records. We just can't give you time for all this, right? The records are here. You can peruse the records. Who stops you? You don't have time to peruse the records.
Take it down the entire position.
There is direct allegation against you.
We will write down the entire depositions and process my notes in the final arguments of this case. It is coming up to 2016.
There is no scope for in judicial jurisdiction. You have to show the perversity. So there is no scope of reappreciating of evidences, right? By drafting also, you must have seen whatever points you were to take. You have taken your points, right? It's a case of 354.
Then it will be fixed for tomorrow elections. We will argue the matter.
The learned counsel for the parties are present. Counsel for the petitioner submit that the matter will be fixed for tomorrow for final hearing. Post tomorrow.
What's a copy of?
ले लीजिए आप इनसे.
आप दे देंगे. Yes, it's not.
कल टाइम मत मांगिए.
नहीं नहीं.
Final discussion.
Item 9, Pinarjan 1205 of 2016.
It may be passed over for two cases.
Pass over.
Mr. Pandey Neeraj has to assist this honorable
He
court.
was here right now. Where has he left?
Your Lordship, case has been called court number 20 for your Lordship.
So all your DLSA story, everything is over now,
Your Lordship,
right?
for few cases only. One or two cases is enough, Your Lordship.
The last provision notices were issued upon the opposite party number 2
You have OP number 2.
Milord, although I was appointed as a MICUS, but thereafter also Milord, notices were issued for proper representation on behalf of the OP number 2.
He is not accurate. Report from DLSA has come. ट्रेसलेस हो गए तब कहाँ से क्या है? आप हैं माइकस रिकॉर्ड्स हम लोग के पास हैं. उसके बाद भी ओपी नंबर 2 अगर एग्री होंगे तो जाएंगे सुप्रीम कोर्ट. राइट, वी आर नॉट हियर टू when the records are here we can decide the case. We don't need any. You are already a MICUS?
Yes, ma'am.
To represent OP number 2?
OP number 2. 27th of April 2023.
That's right. You are seeking a passover?
Item 10, Criminal 1227 of 2016 according to item 11.
Conviction under 138. Earlier occasion was directed to participate in the mediation at Jharkhand.
आप नहीं आ रहे थे तो आपको नोटिस किया गया, आपको इनविटेशन कार्ड भेजे बुलाने के लिए. अब आप अल्टीमेटली आ गए हैं तो आप केस को बहस करें.
We have already informed the petitioner lordship for the same that he had to deposit as a compensation. He is awarded 2 lakh rupees in one case and 1 lakh rupees in another case. But we are not taking interest in this case.
कोई बात नहीं, आपको नो इंस्ट्रक्शन बोल के हम डिसमिस कर देते हैं.
इंस्ट्रक्शन ले लेते हैं सीनियर से.
इंस्ट्रक्शन सीनियर से क्या इंस्ट्रक्शन है? अगर आपको इंस्ट्रक्शन नहीं है तो यही बोल के डिसमिस कर देते हैं. अरेस्ट हो जाएंगे तो अपने से आ जाएंगे.
We have tried our full endeavor in.
कहाँ लिखा हुआ है कि आप जमा करके कुछ हो जाएगा? आप मेरिट पे बहस करिए अपना केस. बताइए क्या पॉइंट है आपका? What is the illegality in both the orders? You have been convicted under section 138. पैसा लिए थे वापस किए, उसके बाद चेक बाउंस कर दिया. यही तो है कहानी. फिर इसमें क्या है गड़बड़ बताइए? साइन आपका था कि नहीं?
एडमिटेड है चेक.
एडमिटेड है चेक. फिर क्या बचा है इसमें?
वो इंस्ट्रक्शन ले लेते हैं.
इंस्ट्रक्शन कुछ नहीं लेना है.
कल के लिए करना.
नहीं, कल के लिए नहीं करना. इसमें इंस्ट्रक्शन क्या लेना है? 138 में इतना मुश्किल से आपको इनविटेशन कार्ड भेजे हैं, कोर्ट ने भेजा है आपको इनविटेशन कार्ड कि आप आ जाइए.
हम लोग भी भेजे थे.
आई डोंट नो, आप तो नहीं अपियर हुए होंगे इसीलिए कोर्ट को इनविटेशन कार्ड भेजना पड़ा. झालसा में आपको कंसिलिएशन के लिए भेजे, उसमें भी आपको कोई इंटरेस्ट नहीं है. राइट? द नेक्स्ट डेट इज सच एंड सच, बोथ द डेट्स. उसके बाद आप तो मीडिएशन में भी नॉन स्टार्टर रहा.
हमारे बुलाने पे भी
नहीं आते हैं ना, तो उनको मीडिएशन भी नहीं करना है तो क्या चीज़ का आपको इंस्ट्रक्शन लेना है? ऐसा बोझिल केस क्यों रखते हैं अपने पास? इसको बहस करिए. नहीं तो कॉन्करेंट फाइंडिंग है तो डिसमिस करने में तो टाइम लगेगा. कुछ पॉइंट है तो बताइए. लंच टाइम में देखिए, हम भी फाइल पढ़ते हैं. लंच टाइम में हम लोग भी पढ़ते हैं. सेकेंड हाफ में ठीक है. टाइम वाइम मत मांगिए. ठीक है. सेकेंड हाफ में पहला केस आपका कर ले. 2:15 बजे पहला इन्हीं का केस कर ले.
Since your lordship has passed an order in exemption that to surrender by today, my lord, I have surrendered by today, my lord, but could not produce the surrender certificate. It would be dismissed for non-prosecution if the certificate is not produced today, my lord. Only my praying that for filing surrender certificate, 2 days more time may be given.
You have filed an IA?
I will file an IA.
बिना IA के कोई ऑर्डर नहीं हो सकता. और नहीं फाइल करिएगा, अगर आज लास्ट डे है तो द ऑर्डर विल टेक इट्स इफेक्ट.
if lordship can only post at any time today, my lord, I
आप
will be
लेके आइए, लेकर आइए, उसको फाइल करके लेके आइए.
my lords.
Extension of time by 5
Extension of
days,
time.
6 days,
My lords,
whatever.
my lords.
You file it. और कम से कम एक फोटोकॉपी तो सरेंडर सर्टिफिकेट का लगा दीजिए.
Yes, sir. That is my specific.
Instruction नहीं,
on
surrender.
affidavit. I will be saying that on affidavit. That he has surrendered.
कब सरेंडर किए हैं
आज ही
पता
किए।
होना चाहिए.
आज ही का डेट था, डेट भी था आज ही का सरेंडर करने का।
ठीक है, आप अपना आइए फाइल करिए, मैं देखती हूँ क्या करना. आपका कैसे? नहीं, आप थे नहीं, अभी होगा आपका केस. आपका
हम लोग 2 हफ्ता के अंदर आरजी के यहाँ डिमांड ड्राफ्ट डिपोजिट करते रहे.
ऐसे नहीं है, अभी फाइल मेरे पास नहीं है.